Today we're talking about a very much practical issue, practical thing, which is called a letter of formal notice. Pretty much every time when you are going, or at least thinking of going to sue somebody in court, to initiate a lawsuit, legal proceedings, by the Civil Code of Quebec, you have, first of all, when it comes to civil litigation, of course, you have to send this letter of formal notice, or the famous mise-en-demeure. So we are talking about it now just in more detail today. What do you usually find in a letter of formal notice? Well, first of all, of course, you can hire a lawyer to do it for you. And if it's a complicated, complex, difficult issue, probably it's a good idea to hire a lawyer. But when it comes to something less exhausting, let's put it this way, and maybe you simply don't want to spend, well, quite a hefty amount of money to hire a lawyer only to write a letter, you can do it on your own, and from the legal point of view, it will have the same weight as if it was drafted by a lawyer, as long as the formalities are observed and as long as it was properly delivered and you have proof of that delivery. So, first of all, let's restart it here. Usually you put this confidential without prejudice thing, because sometimes if your wording is not very much fortunate, there might be something that might be seen as admission or something like that. So it's not that this notion of confidential without prejudice protects you completely, but at least it adds some protection. Then you choose the way how you deliver it. It might be via registered mail, because whatever way you choose, you have to have proof of delivery. Registered mail, because usually you can download this proof from the side of Canada Post. It can be by bailiff, but it's more expensive, though, well, the proof is guaranteed this way. Or if you can later prove that the person you are sending a letter to normally uses one particular email address, you can send a PDF copy to that email address, and with, again, the proof of delivery, or at least a copy from your own mailbox, you can use it still. Then what should be there next? It's a heading information, like who is writing, to whom, usually full name and the address and maybe phone number and email address if known of that person should be there, and the date, of course, so that later again you could prove that you used proper information about the person and that it was sent timely at a certain date. Then when you finished with that formal part, you start with the subject. What is it about? Maybe it's about the contract of purchase and sale of some property, maybe about some latent defect, vis cachet, maybe about some family quarrel, or in the sense, like, for example, you think that your uncle is taking some part of the inheritance that should go to you. So I'm not talking about divorce. I'm talking about like family issues in more general term. So when you decided how to express concisely what's the matter, then you introduce yourself, not because the other person doesn't know who you are, so it might be, but might not be. But for the purpose of this letter, who are you? So you're writing to that person as to whom, like a guardian of some dog, for example, or like an owner of some building, or like a manager of some company. And with respect to this particular conflict, who you are. Maybe a customer, a client, maybe the dog had bitten your dog, or just spoiled your new tires or something like that. So for the purpose of this particular communication? What's the capacity of that person? What's your capacity? Then, when it's clarified, you go to the story itself. Usually it's numbered. So you write something like in chronological order, like on this date, this happened. On this date, this happened. On this date, I noticed. On this date, I contacted you via phone. On this date, you responded me with a postcard. On this date, something repeated itself or something like that. It's customary, but usually not necessary to mention what actual evidence do you have. But it depends. If you're writing this letter for its actual purpose, like the purpose that was envisaged by the law, which is to start some kind of negotiation and to get to some kind of agreement and avoid litigation, then it's preferable to show what kind of evidence do you have in advance, so that the discussion might be more on the point. But it might be that at this particular moment you don't have this evidence yet, but you're expecting to have it closer to the time of litigation. So again, you might mention and even attach your evidence. You might not. Usually that's the biggest part of the letter. And again, depending on how complicated the story, it might be several pages, it might be several paragraphs. Sometimes even like dozens of pages, but usually it's not a good idea to get into that much of detail. Then, next part, when you explained how you see the facts, you put there your claim. So what do you ask? What's your demand? Sometimes this letter is called demand letter because of this. That somebody stops doing something, that somebody pays you something, that somebody compensates you for something, that somebody provides you something like information or whatever, or documents. And next, you give time to do that. It should be reasonable. Because if you're asking to provide you something rare, it's not reasonable to give only 1 day. Because probably it's physically not possible. Or some documents that are yet to be collected or yet to be just organized or discovered or whatever. So it might be several days, might be even several weeks, sometimes even several months. The time should be reasonable. And once this term is over, only then you can go to court. Once the term is over and you have not received any positive answer to that, then you can go to court showing that, okay, the letter was sent, there was no answer or negative answer, and now you go to court asking for the decision about that. There may be several terms, like a term to respond and term to do something. And usually when the other party responds within the term and maybe with the idea to start negotiations, if it goes well, then okay, you can just set aside the letter and proceed with negotiations. But if it doesn't work this way, okay, then you have it. You have the letter, you have proof that it was delivered, you have either proof of negative answer or in not satisfactory answer, or that there was no answer, and then you can attach it to your claim in court, to your application in court. So after the term, you put the formal part, the notice. There is no particular wording how you phrase it. So one of the versions is here, but the idea is like, if you do not do what I ask you to do, if you do not respond in time, if you do not cooperate, then I will go to court and I will have to protect my rights with other legal means. Sometimes it's added like without any further notice or delay. And The famous last phrase is please govern yourself accordingly. Again, it's not necessary, but it's customary to have it there. So as you can see, it's possible to save yourself some money, at least, maybe not time, but money, and do it on your own. Sometimes, again, it might be like a middle option. So you draft it on your own, and then you go for one consultation with a lawyer just to review and maybe edit it on the spot. And if you did not do like so many mistakes that it should be redrafted completely, then probably it'll cost you less at the end of the day. So this is it. Your letter of formal notice. As always, I hope that you won't need that information, but if ever, that's what you can do. Thank you and have a nice day.